23CCCR 0484, case of style, the state of Texas versus Christopher Living. Mr. Living, would you please come forward? Mr. Living, your full name is Christopher Living? Yes. How are you doing, Mr. Living? That's good, Mr. Living. You're represented by your attorney Lindsey Scott. Attorney Scott, how are you doing?
Good, Judge. How are you?
I'm doing fine, thanks for asking. The state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
You want Your Honor yourself?
I'm doing fine. Now, Mr. Hubel, I have before me a motion to dismiss Mr. Living case,
That's correct.
and the court is signing this dismissal. Mr. Living, your case is being dismissed. You'll be able to get a copy of the dismissal from your attorney in about 1 or 2 minutes. Okay, Ms. Scott and Mr. Living, you can stand in front of the court coordinator, get a copy of the dismissal. Yes. Let's fill this one. Yes, sorry, name.
Mr. Jesus Hernandez via the waves.
Villanueva, okay. This is cause numbers 23CCCR 2188 and cause number 23CCCR 2190. Both cases are styled the state of Texas versus Jesus Hernandez Villanueva. Mr. Villanueva, is that your full name?
Yes.
How are you doing, Mr. Villanueva? I'm doing fine, thanks for asking, Mr. Villanueva. You're representing your cases by your attorney Jared Gilthorpe. Attorney Gilthorpe, how are you doing?
Doing well, Judge, thank you.
State is represented in this case by attorney Erica Porter. Porter, how are you doing?
I'm doing great now.
And Mr. Gilthorpe, what is your announcement in Mr. Villanueva's case?
Judge, we have completed discovery. However, the videos that were provided were not for the correct case or somebody else. I'm headed up to the DA's office to get the correct videos now.
Okay,
I've spoken to Ms. Hughes about it, and we're gonna try and sort out the correct video issues.
okay. Give us a reset date, standard reset. Do we have bond conditions in his case? Let's see. Do that in a second.
Okay.
I don't see none. Good, make up some bond conditions.
He currently has a breath lacerated in his cause.
Okay, I just need to make sure we have a written conditions, because if he has some additional conditions on his bond condition besides the
Right,
toxilizer.
right. Lieutenant,
In a lot.
that's the one we focus on.
Yeah. Okay.
We just came from there. Yes. Yeah. Haven't said it yet, but we just came from there.
Okay, because there's really nothing that you got anymore. I just wanted to see what's it gonna be soon. Oh, yeah.
Okay. Hey, Mr. Villanueva, I have some bond conditions that I'm going to go over with you. And then we'll give you a copy of these bond conditions for your record. The document that I have before me is titled Standard Bond Conditions in County Court at Law Number 2. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number one, that he speaks Spanish.
No, he speaks English.
Oh, okay.
Sure.
Number one, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? You understand that condition?
Yes.
Okay. Number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
Okay. Condition number 3 does not apply. However, condition number 4 does apply because you have an offense that is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states as follows: a defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. Now, your attorney has informed the court that you already have an interlock. Is that correct? Okay, so you understand that condition. Now, condition number 5 states, the defendant shall obtain, maintain, pay for, and have no violations with the ignition interlock device or mobile breath device. Any violations will be grounds for revocation of your bond. Do you understand that?
Yes.
Condition number 6, the defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition? And I have a copy of the locations of AANA meetings in our Jefferson County area. And I also have a sign-in sheet that you would have to bring with you when you go to the meetings. A sponsor will sign it verifying that you did attend. And then when you come back to court, you will bring the sign-in sheet with you so that the court can verify that you are attending AANA meetings. Do you understand that?
Yes.
Okay. Now, condition number 7. Defendant, you have a UCW case, unlawful carrying a weapon case, so the defendant is prohibited from possessing a firearm ammunition unless defendant is a peace officer, as defined by section 1.07 of Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Okay. The court coordinator is going to make a copy for your records. And once you get a copy and you get your reset from your attorney, you're free to go. And you have a blessed day. Okay, Mr. Just have a seat in that chair. Here, you make a copy. Tammy Lynn Johnson. Good morning. Ms. Johnson, your full name is Tammy Lynn Johnson. How are you doing, Ms. Johnson? I'm doing fine. Thanks for asking. Now, Ms. Johnson, your attorney of record is Attorney Matthew Morian. Okay.
That's correct. My name is Joe Glenn Kayla. I'm standing in.
Joe Glenn Kayla.
Kayla, K-A-H-L-A. Yes, sir. I'm standing in for Mr. Morian this morning.
And I did speak to Mr. Moran this morning in my office.
Okay. How are you doing, Mr.
I'm
Kayla?
good. I'm good, Your Honor. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Johnson, does Attorney Kayla have your permission to stand in for Attorney Morian? Okay. Attorney Kayla,
Yes, sir.
what is your announcement in Ms. Johnson's case?
Judge, we're asking for a reset in this case. It's my understanding Mr. Morian has been in negotiations with the state.
Okay.
And we're asking for a little more time.
Okay, how much time do you need?
Probably, what's,
Standard reset, or do you need more time?
I think a standard reset would be.
Okay.
Would be fine, Your Honor.
Give us a standard reset on Cammy Johnson, page 5 of the announcement docket, the last one on page 5.
July 15th.
July 15th. Okay, Ms. Johnson, your case will be reset to July 15th, 2024. Attorney Kayla will get your reset. Once you get your reset from your attorney, you're free to go. And you have a blessed day, Attorney Kayla. Next meeting, you're free to go as well.
Thank you, Your Honor.
You're welcome. Yeah, you reset.
Yes, ma'am.
Next two cases are cause numbers 23 CCCR 0380. Excuse me, let me repeat that. Cause number 23 CCCR 0308 and cause number 23 CCCR 0309. Both cases are styled the state of Texas versus Roberto Romero.
The case is gonna be.
Oh, it's gonna be, okay, just have a seat, and then once the plea is ready, we'll call y'all back up.
Thank you. Joe. Okay.
Oh, okay, I thought you had another case.
No, thank you.
Okay. I have any other attorneys? Here we go. Here we go. You did. Who's attorney? Who's Paget?
Thank you very much.
Yes, sir.
That's Paget's case. He's not in here. I'm gonna send it back to you. Paget is not here, so, I'm gonna send it back to, huh?
He's welcome.
Let me just.
Okay, but if you have another one, I won't be able to get into
I
it.
don't.
I'll just leave this up for right now. And we'll say. Spencer. Kurtz is on that. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Both cases are styled the state of Texas versus Cleveland Thomas. We have to wait for, who's the prosecutor on that one? Oh, we got a motion for confidence in this case. Oh, let's see what the, this is on, this is on. Jury docket, okay.
Yeah. Okay, you said you were gonna file a motion with competency.
What is this motion that's filed? Let me do this here. Pre-trial, jury trial. This is Mr. Thomas. Oh. Cleveland Thomas. There's that. Appointment, okay, motion. Motion is proposed order. Here we go. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Both cases are styled the state of Texas versus Cleveland Thomas. And Mr. Thomas, is that your full name, Cleveland Thomas?
Yes, sir.
Mr. Thomas, would you please raise your right hand? Mr. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Thomas, you may put your hand down. Mr. Thomas, you're represented in your case by your attorney, Attorney Benjamin Jeffries. Attorney Jeffries, how are you doing?
Doing well, Your Honor. Thank you.
That's good. Now, Mr. Jeffries, I have before me 2 motions that you filed. Now, are you waiving a record in this case? Now, Mr. Thomas, your attorney has filed 2 motions. Both motions are styled motion for competency exam. And so the court is going to conduct what is called an informal inquiry. And pursuant to Article 46B, Section 46.004. And now, Mr. Jeffries, your client has a right to have a public hearing pursuant to Article 1.24 of the Texas Code of Criminal Procedure. All proceedings and trials shall be public. However, pursuant to the case of Lilly versus State 365, Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as interest in security, preventing the disclosure of non-public information, or ensuring that the defendant receives a fair trial. Mr. Jeffries, are you questioning that this proceeding be closed to the public
Yes, Your Honor.
to prevent the disclosure of non-public information?
Yes, Your
The court finds that the party seeking the closure of the hearing has advanced an overriding interest that is likely to be prejudicial to his client in that it will disclose non-public information to the public. The closure is no broader than necessary to protect those interests. The trial court has considered other reasonable alternatives, and these findings are adequate, and therefore, at this time, this portion of the hearing would be closed to the public.